Hello, my name is Suzanne Sellers, and today is Thursday, March 28th, 2019. This is video number 6 that I'm creating in a series of videos about why the federal law named the Adoption and Safe Families Act of 1997 needs to be repealed. Today's video, I will talk about options. It is a section in the Adoption and Safe Families Act of 1997 with the acronym ASFA. There's a section in ASFA with some options provided to state agencies by law. And those options read something like this. I'm going to paraphrase. If in the most recent 15 of if in the last 15 of the most recent 22 months a case has been in the system, a state agency shall move towards termination of parental rights for that parent unless, and then it gives 3 options that state agencies can opt not to move to termination of parental rights. And those 3 options are: A, if the state at its own option determines that the child is with a relative and the state agency wants the child to remain in the care of that relative. Or B, if the state has determined and documented in the case plan a compelling reason why termination of parental rights would not be in the best interest of the child. Or C, if the state agency has failed to provide services that it deems necessary in order to return that child home safely. I have a problem with all 3 of those because they have words in there, qualifying words that gives too much wiggle room to state agencies. In the first case, at the state's own option, it can determine whether it wants to leave a family in the care of the relative. That should not be an option. If a child has been removed from their family of origin and put in the home of a relative and that child is being safely cared for in that relative's home, the state should not have the option to remove from that safe home if they choose to. B, if in option B, where the state has to document it in the case plan throughout the case that it has a compelling reason. The word compelling is not defined. So the state can say, I don't have a compelling reason, and they don't have to justify why they don't feel compelled to not move to termination of parental rights. And then in the third option, that's not satisfactory because who's gonna tell on themselves? It says the state agency can, if they fail to provide the services in order to return the family home, they can stop termination of parental rights. But state child welfare agencies are in the business of providing services to safely return the child home. That is why the whole act is written. So why would a state agency say, yeah, I didn't do my job, so I'm just not going to break up this family? That seems like hogwash, and it seems like crap. And I think the Adoption and Safe Families Act of 1997 is full of crap, and it needs to be repealed. Will you please help me? Thank you.